Recording in progress.
And see. Good.
Good morning. We're here for the Kentucky Legislative Ethics Commission meeting on Tuesday, November the 18th, 2025 at 10 a.m. or a little bit thereafter. We have a couple of folks that may join us hopefully soon, members, but we're going to go ahead and get the meeting started because we got a lot of work to do and we don't want to keep anybody waiting any more than we have to. The first thing I would ask for is for Danita to call the roll. I'm going to remind all members Ms. Tanya's on Zoom, and Mr. Simpson may be on Zoom after a while, and Mr. Lilly. So when you talk, you have to key your microphone for them to hear you. Okay. And so when your name is called, would you please report that you're here and tell us your physical location?
Christopher Lilly. Dave Nicholas.
Here in the capital city.
Mike Scholl.
Here and in the annex.
Tanya Pullen.
Here, coming to you from Greenup County.
Gail Russell.
Here in the annex.
Sal Santoro.
Here in the annex.
Arnold Simpson. We have a quorum.
We have a quorum. We have the minutes of the October 14th, 2025 meeting. You've been sent those previously. Is there a motion to approve those minutes or any changes? Is there a motion?
So move.
Second.
Motion made and seconded. Any other changes, discussion? Appearing to be none. All those who favor the motion signify by saying aye.
Aye.
All opposed, no. The ayes have it, and it is so ordered.
Chairman Chris is logging in. I'll mark him here. He's coming on Zoom. Chris Lilly.
Oh, good.
Okay.
Chris, are you with us? I guess he's got his phone on. His son had a wreck this morning, and he's gone to help him. He is not injured. That's a good thing, but they're trying to get everything squared away. And so Chris is assisting him, and he's going to get with us on Zoom. We have 5 separate motions to consider in regard to 24 LEC 03 and 24 LEC 06. Those are a renewed motion to dismiss filed by Representative Grossberg, a motion to quash filed by Representative Grossberg regarding notice of intent to acquire health records by Enforcement Council, a renewed motion to compel for sanctions and to continue the adjudicatory hearing to a later date filed by Mr. Jenkins, a motion in limine by Mr. Jenkins to exclude certain evidence from the hearing, and a motion in limine by Representative Grossberg to redact certain deposition transcripts. Each side, if they wish, may address these motions in open session prior to the deliberations of the commission. I'm appointing Mike Scholl, as I have in the past, my vice chair, as the hearing officer for this activity.
Thank you, Mr. Chairman. Before we start on the motions, the 5 motions that the chair just mentioned, I'll ask counsel for the respondent and enforcement counsel, are there any part of these motions that you believe should be heard in closed session due to any personal information either by a respondent or any of the other parties? Okay, thank you. Enforcement counsel. Okay, we just wanted to extend that question. We have, I think, 5 motions, about 150 pages of briefing on them. I guess probably the best way to proceed and I guess let me ask this: do the parties wish to actually be heard on these motions and present any argument? Okay. So to keep the subject matter of the motions distinct and separate and not get them conflated, I think the best way to go about it would be to take them one at a time, and I'll ask the party making the motion if you can keep it to about 5 minutes or less on the argument, and then we'll hear from the other party that's responding to the motion, and then we're not going to break each time and deliberate for each motion, but we'll hear them in the order in which they're presented. So for the first one, this is the motion to dismiss, followed by the respondent, and I guess Ms. Whites, will hear from you first.
And by the way, I do want to report that Representative Simpson has joined us, so we have an additional member here.
Ms. Whites, whenever you're ready.
Thank you. Dana White, counsel for Representative Gross. This is our renewed motion to dismiss or motion for summary judgment. This case is really.
Please push your microphone button.
Thank you. Can you hear me now, Representative?
Yes, thank you very much.
You're welcome. Anna Whites for Respondent Representative Daniel Grossberg. This is our renewed motion to dismiss and motion for summary judgment. This case has roamed very far afield. It started out with so many charges, and we're down to 3 relatively minor administrative matters. But I am concerned that there continues to be a lot of discussion about bias and concerns. I know that there was another attorney on behalf of Representative Grossberg engaging in discussions with the executive director and reporting to the client, well, it seems like the commission's already made up their mind on several of these charges. Mr. Jenkins, counsel for the commission, in several of his pleadings, is roaming far outside these minor matters and going to the medical board, or this therapist is not a good enough therapist. I think we're really losing track of the sight that these are 3 very minor matters, that there really are not witnesses on most of them, and most importantly, that key discovery, which is the policies and procedures and training that govern the behavior of the state representatives, was never made part of the record, and everyone just throws up their hands, including Enforcement Council, and says, I don't have that, I can't get that. Representative Grossberg was a freshman legislator. He saw his leaders drinking in the office, eating gummies, taking personal political contributions in front of staff on state time in the Capitol. He was not trained in how to act, other than the brief 2 hours by the commission, which focuses very appropriately on how to be a good legislator and not how to work in the office. And what was any freshman legislator to do? I think we see freshmen make problems every year because they are not trained. And we've asked for those materials. We've asked for the LRC report because the newspaper and Mr. Jenkins has lots of accounts. Oh, the LRC report is terrible. Representative Grossberg, who discussed that report with the LRC investigators, has said, that report is not terrible. They told me I didn't use professional language in emails, and I texted my staff too late at night and was too demanding. And they gave him professional coaching. That dovetails with what we see in his emails. They're late at night. They're a little unprofessional. He's been very genuine, but without that report, without the training, without the manual, without key exculpatory evidence in this case, we cannot move forward. It also is an issue that the witness, the only other witness to the conversation, or party to the conversation revolving around the alleged quid pro quo, says it never happened. In discovery, Mr. Sheth had his interview turned over and it said that never happened. I never told you that. Representative Grossberg has said the same. The alleged people who were watching the untrained folks making contribution calls on behalf of the caucus, not on behalf of Representative Grossberg, have said, well, weirdly, there's no recordings, there's no training, we took no contemporaneous notes. We have Representative Grossberg's texts and the two parties. And so we're looking at matters where it's very clear that the commission doesn't have witnesses and evidence to back up what it's saying. We're looking at a case where bias is rampant. And we're looking at a case where key exculpatory information cannot be brought forward. The record is clear. Quid pro quo never happened. The record is clear that the discussions with the issue advocate, Ms. Curtis, was focused just on bills and acts before the legislature. It was unprofessional, perhaps, but it was focused on work in the office, doing work. Perhaps some alcohol was consumed, just as the leaders testified in their depositions, both of them, oh, we drink in the office. Everyone in the Capitol drinks in the office. Everyone in Frankfurt drinks in the office. And I don't know about you. I don't drink in my office. And I don't know a single legislator who drinks on legislative time. It was an unprofessional environment, no training, no policies, no procedures, no follow-through, and key exculpatory evidence is missing. We need to look at this and say there are no ethical breaches. There is nothing in the record that shows that he breached any of the code of ethics, and that is what is before this commission. This commission cannot decide other issues, extraneous issues or bias or made-up issues. You can only decide what is before you under the code of ethics, and we don't see any of those. The only charges that Commission's counsel has said is, well, he engaged in these conversations for personal benefit. But both parties to the conversation, the issue advocate and Representative Grossberg, said the conversation was about legislation and bills and matters before the commission. There is nothing here that can move forward. Representative Grossberg and his family and his wife have suffered through 2 years of the papers printing things that are entirely unrelated to the three issues before this commission, and it's time to put an end to it before session starts. So we'd ask you to either grant the motion to dismiss or grant him summary judgment in his favor, because key exculpatory evidence is missing and we have not been able to get that. Thank you.
Thank you, Ms. Whites. Before, I think there may be some questions maybe from the commissioners, but we'll ask Enforcement Counsel to respond, and then I'll open it up for that.
Thank you. First, I'll stand by the response that I filed. A couple of things in response, though, to what Ms. White said. She has said at times that I have refused to provide information. I've never refused to provide anything. I've given her everything that I have. Anything that she claims is due from LRC, she could have obtained from LRC or her client. She has referred to a mandatory closeout letter for sexual harassment claims, but has not given you a citation, nor could she, for any requirement in law of a mandatory closeout letter for sexual harassment cases. It might be preferred, but there's no requirement. She speaks of legislators not being trained how to act. I believe we all pretty much know it's not a good idea to have 5 to 8 shots of alcohol and ask someone in our office about their sexual habits, about their sexual organs. That goes far beyond the issue, the main issue being discussed. And we heard Ms. Curtis talk about that. The motion for summary judgment talked about hearsay evidence. You've heard direct evidence from Foxy's about what occurred. I don't know why they say there's hearsay. You heard the man say, I was told he's a legislator and he said he could shut us, or he threatened my business. You heard that. That's direct evidence. That's not hearsay. We have turned over recordings of interviews. We've turned over summaries of interviews that we have of all of them. Ms. Whites is concerned about the motivation of the complainants. The motivation is not relevant. We're at a point now where we have 3 direct probable cause findings of ethics violations. That's what's before the commission. Did this conduct occur? It did or it did not. The motivation of the complainants, who are not parties at this point, is not relevant. If we get into motivation of the complainants, then we will end up having probably 30 witnesses, because I'll bring in everybody who talked about who brought complaints to the commission, and evidence of all of those other allegations will come forward. But those aren't the issues here. The issues here are just the three issues. There's been discussion about the medical records. I'll get to those more appropriately in a few minutes when we talk about another motion. She says that I have referred to the LRC reports as being terrible in some way. I've never referenced anything from an LRC report. I don't know where that's coming from. LRC has not cooperated with me. I've been able to get nothing from LRC, so I don't know what is in an LRC report. If LRC made a report, her client should have it, but I don't. LRC never gave it to me, to her as well. That could have been subpoenaed. In the reply that was filed, it referenced that there were a lot of false claims made for improper purpose. The commission has not found that there were any false claims made. The commission has found that claims may not or did not rise to the level of being, or where there was probable cause to find that ethics violations had occurred. The commission has not found that the conduct alleged did not occur. The standard for dismissal is of an action is not appropriate where you bring in extraneous information, which we're doing here. Extraneous information is the information that would be in the record. Ms. Weitz has referred to other things from interviews that she's read. Those interviews are not part of the record. The only thing that we have in the record is either that the commission made its determination on was the matters in the that were discussed at the preliminary hearing, and then in the documents that have been filed that have been supported by affidavit or verified before the commission. So that gets us to what the standard is for summary judgment, and that is whether there is a genuine issue as to a material fact. We've already made the finding that there are issues to support the commission's probable cause findings. So there are facts to support those. Ms. Weitz says there are other facts. Just because there are other facts doesn't mean that the facts that the commission has based its findings on aren't there anymore. They're there. They may be disputed, but those facts are there. There has been an allegation that even as to, she was referring to the Subway owner. The Subway owner actually, over the course of 2 attempts to contact him, contradicted himself. At first, he wanted to talk about it, and then he didn't recall having a conversation at all. Well, we know that's not correct. So what we have had in the record is the affidavit of the consultant who was in charge of the fundraiser, and then you had the sworn testimony of the commission investigator. There was question about a state vendor list, and but there is a vendor list. No, the issue here is a state catering vendor list. Anybody can register to be a vendor in the Commonwealth of Kentucky. That doesn't mean you're going to get a contract. You still have to apply for it. But that's the Finance Cabinet maintains a vendor list. What this was talking about was a catering vendors list, and there is none. I could go through the reply line by line and discuss. I mean, we spend time talking about Tourette's. Tourette's came up. You know, it wasn't in the initial medical report. It was in a subsequent medical report. That just appeared. That's really not, well, again, it was a medical report, but not a medical record. There's been discussion about, in the reply, about the blood alcohol chart from Ford's advisor. What was quoted here as that it would take approximately 12 drinks in a 3-hour period for an average-sized adult man to reach impairment of 0.08. That's just not correct. I looked at that chart. That's not how I read it. So that's just false. Again, I'm happy to answer other questions, and we'll get into the medical records in more detail soon. But there is no the standard for summary judgment has not been met, and so I'd ask that motion be overruled.
Okay, thank you, Councilman. Do any members of the commission have any questions for either council on this point?
Yeah, I do. We've heard a lot about an alleged LRC report. And I want to make one thing perfectly clear to folks is we don't have an LRC report in our custody. We've never seen it. We've never had it. And if there is such a report, we're not withholding that from anybody. It would seem to me, has Representative Grossberg asked LRC for a copy of that report?
Yes, he has, and we also filed an open records request, and they said unequivocally that will never be provided. He does not have a copy of it, but both complainants said that is what they relied on in bringing their charges. They speak of it very often in their depositions. Both Mr. Jenkins and I represent clients before various clinical and medical boards who also have complainants, and then the board prosecutes. In every single case I've had, if you ask the board and their counsel, hey, I need the clinic that this person practiced in, I need their policies and procedures to see if my client was trained or how my client was trained. They provide those. They don't use this, oh, we don't represent the complainant, and so nuts to you, you don't get that key evidence. That is what the complainants base their initial complaints on. That's what they say in their depositions. That's what they'll say under oath. And I want to point out again, Mr. Jenkins again says, if you make me go to trial, then I will bring in evidence of other allegations. This is limited to the 3 charges. This body did in fact find that there was no merit to the car, the claims of Medicaid fraud, other issues that are in the complaint. We need to tailor it to this case, and in this case, there are no genuine issues of material fact about any of these charges.
Okay, I just want to make one thing clear is that nothing we've done or said as a commission has any reference to any report from LRC.
I
We haven't
appreciate
relied
that,
on
yes.
anything. We don't have anything. It's, I'm a little concerned about, things that are said in some of these pleadings that imply that we haven't been fair about this.
And I do
And I
not,
wanna
sir,
say-
want to say, when I'm saying that, it is the commission as in, I'm probably slamming counsel or the investigator. I understand that the members of the commission are not integrally involved in prosecuting this. You're just in a difficult position because you are judge, jury, and prosecutor via your legal arms. And so I am not saying you, Mr. Nicholas, did something wrong or prejudicial. I'm saying the way this case has played out has been unfair, inappropriate, and prejudicial. That as the commission, I'm sure you want to see the LRC report and the policies and procedures as well.
If it's introduced and if it's important to the case, it's fine. I'll be glad to see it. I'm only going to view and only going to make a decision based on what I see in the hearing that we're going to have. Okay?
And that
then-
would be the problem, because the key exculpatory evidence has not been provided.
But the thing of it is that how do we get exculpatory evidence if they don't give it to Representative Grossberg, and they won't give it to us, and they won't give it to council, and they won't give it to you?
I think at that point you have to do what other boards and commissions do in the same place, which is say, I'm sorry, we don't have that, we can't move forward.
Well, with all due respect, that was never an issue at the hearing on whether or not there was enough evidence for us to move forward on that. And so I'm wondering why it keeps being jockeyed around when it's not something we've ever considered. It's not the basis of this complaint or any complaint.
It is the basis of the complaint, because that is what the complainant said under oath. We made this complaint because of what the LRC told us. They both said that under oath.
But that's not been exposed to us. We didn't make our decision to move forward in this case based on that. Because
All right.
we've never seen it, never heard it, never talked about it. So my point is that I don't really like, I'm chair of this commission, and I take it a little personally that the reputation of this commission's been sullied by facts that are not true. And I'm always going to defend my commission and my members for what they do. And I think if you can produce that and you want to enter it into evidence, that's fine. But right now, it's not something we have or anybody has, and it's not something we've withheld, and we're not trying to be prejudicial about this at all. I think we've tried to be extremely fair about it.
Mr. Chair, may I comment on your question as well?
Yes, sir.
The LRC sexual harassment policies are not at all relevant. This has not been an investigation of sexual harassment under LRC policies. This has been an investigation of whether respondent committed violations of the Code of Ethics. That's it. Respondent, unlike the other boards that were referenced that we may have practiced before, this is not a question before LRC, before the Legislative Research Commission, as to whether respondent violated some codes of conduct of the House of Representatives or Senate or the Chamber. This is a question of whether this commission's rules of ethics have been violated. Whatever LRC says about sexual harassment is not why we're here. We've made the determination, the commission has, that there's probable cause to go forward on three separate issues.
I'd like a clarification. The matter before this body is not sexual harassment, and that is one of the huge problems that we have, because the newspaper and the complainants and others keep saying that is what is before the Ethics Commission. And here is your counsel saying sexual harassment policy. I'm not interested in the sexual harassment policy, except insofar as it limited the ability of anyone concerned to immediately address an issue, and is wildly inappropriate for that reason. But what we are talking about is, how are you trained? How are you trained to act professionally? How are you trained about drinking in the office? How are you trained about texting? One of the leaders texted her feet to various married men. You know, there's clearly a lack of training here, and that leads to people misunderstanding each other. And with regard to 12 drinks, I think Mr. Grossberg was clear. It was a half-size shot glass, if that. He will produce it at the hearing, and that's 4 to 6 drinks over 4 or 5 hours.
I'm sorry, I didn't say 12. I think I said 5 to 8. But again, we're playing loose with what's been said. I've been very clear from the very beginning. What we're dealing with are allegations of violations of the Code of Ethics. That's it. Council has raised sexual harassment. I'm talking about violations of the Code of Ethics. That's what we're going to hear about at an adjudicatory hearing. She mentioned the need to focus on the 3 remaining issues. I agree. But she's talking about bringing in motivation of the people for filing the complaints. If we bring in motivation, then she's opening it up to all of the allegations. Now, we would only have a determination as to the final 3 that you found probable cause for. But the commission has investigated many cases before where legitimate complaints were made, questions were made about conduct, but the commission found that there was no ethics violation. The commission has found that with some of the allegations here. But the commission has also found that there's probable cause to believe that there are 3 potential violations of the ethics code that have occurred.
Anything further that you have, Mr. Chair? Is there any questions by Commissioner Pullen, Commissioner Lilly, or Commissioner Simpson? Assuming none there, I guess I've got a few that I wrote down. One is, and I appreciate what Ms. White, you said about, well, this is a little bit different procedure or animal than other bodies in terms of how it's structured. First, if it's characterized as a motion to dismiss. All right, if it's a motion to dismiss, then the standard would be, okay, do the complaints allege something where, if taken as true, the matter can be dismissed? I don't see that here. It has sort of also been discussed in the replies as maybe also a motion for summary judgment. And again, going back to okay, how is our process here a bit different than other actions, either a civil action, purely civil action, or a purely criminal action? If it's a civil action and you're using the rules of civil procedure, well, you don't have a probable cause hearing in a civil action. And I understand what enforcement counsel is saying, which is, without getting into really the substance of the probable cause preliminary hearing, there were witnesses at that gave direct testimony as to the underlying facts and issues here. So I'm having difficulty saying, well, we're just going to ignore that, because I think that is, in the record here. So we have heard testimony as to the potential violations that have occurred, and this body voted on that and said, well, we do find that there is something here on which to proceed. And so if the standard is, okay, if we were to treat it as a motion for summary judgment, aside from anything that's in the pleadings, I don't see how we can ignore that and say that testimony that has been heard at that stage has to be ignored and assumed to be irrelevant here. So I guess that's one of the things that I find problematic, even if it's treated as a motion for summary judgment rather than a motion to dismiss. All we can do, and I understand that there are claims that maybe the complaints were motivated by bias of some of the other legislators, but all we can do is just look at what is here in front of us when we get a complaint. So if there's other actions by other members of the legislature that respondent feels were also violations of the ethics code, we can't really do anything until somebody makes a complaint, and then it comes before us, and we go down the procedural road that we did in this case. So while that may have happened, that other people did certain things, it's not in front of us yet. It's not in front of us at all right now, so we can't really act on that. And I understand that respondent is saying, well, there may have been bias as motivating people to make the complaint. But if, I guess as an example, if the Ohio State football program calls the NCAA and says, Michigan, our rival, is committing violations of NCAA policy, the NCAA is like, well, okay, we can understand that maybe you have a reason to make this allegation, but they have to say, okay, is there substance to the allegation? You know, were there violations of that? And that's all we're trying, I think, to just shut out everything that's extraneous and simply say, you know, there are alleged violations. Is there substance to those? Is there evidence of that? Is it something that we need to move forward with, and confine it just to that? I do want to make sure that I understand. So the LRC report, I understand that Enforcement Council is saying none of the information in that is the basis of really these charges as they have been investigated. Ms. Oyes, are you saying that LRC has never given a copy of that to your client?
Correct.
That he cannot obtain it and they will not give it to you?
Correct.
And has that been subpoenaed, or have you? Because I don't have a
No,
motion to compel
we have
anything
not,
either. With
we have
respect-
not subpoenaed. We requested that the commission bring it forward and request it itself, because it is necessary. The LRC investigated the allegations with the issue advocate. The LRC investigated the texting allegations. The LRC investigated the subway allegations. Those are before this body. And the issue is not, is there evidence? Did other people act poorly? Did Representative Grossberg act poorly? The question before this body is, given the code of ethics and the statutory requirements, do any of these fit those standards? We can feel however we want to feel about Representative Grossberg or any of the other parties or witnesses, but these are not violations of the ethics code, and that is why the matter should be dismissed.
Well, I mean, and I think, well, that is true. Are the allegations, is there substance behind those allegations? And are those actions, if true, violations of the ethics code, which I think is what we have done at the probable cause hearing with some of them. It wasn't a matter necessarily of did we feel the conduct was actually engaged in or not. It's that if it was, would that be a violation of the ethics code? And some of those were dismissed on that basis. But in terms of the LRC report, I mean, again, if you felt that the commission had it, I think it would be a motion to compel, to which Enforcement Council would respond, and then we would say, do we have it?
I think Mr. Jenkins was clear and said, I don't have that and I'm not getting it.
Right. So I don't know that it's incumbent on the commission to say that we are going to go and obtain a document that you can't get. I'm taking you at your word. You can't get, and then give it to you. It would be like if I said I had a client and I felt that their phone records that were in the custody of whatever carrier, that they were going to provide exculpatory evidence as to my client, and I'm going to put it on the prosecutor or the court that they have to go get that. I mean, I understand that it would be helpful to that person's case, but it seems that's incumbent on the defense, is it not?
I think it's the
that?
duty of the investigator and the prosecutor to provide exculpatory evidence. As we've said, this is a quasi-criminal proceeding because of the probable cause. I think a prosecutor can't say, I'm not going to get those. I know we relied on them, and the breach of them is what led the complaint to come before me and the grand jury, but we're not going to give you that. That, in my mind, is where it is.
But if they don't have it, then that's a completely different story.
I think
is
a
it not?
prosecutor has to make reasonable effort and has to produce what they are relying on to make their complaint, and what they stated under oath is we relied on them to make a
Okay.
complaint.
Have you asked for a subpoena or issued a subpoena to
I
LRC?
will request a subpoena, and we'll see. I think the LRC will probably say no to that too, but we'll try.
Well, I'm just saying, if you haven't done that, it's hard for me to look at Mr. Jenkins and be like, why haven't you done something
I
when
think it's
it
his
hasn't been
duty.
subpoenaed?
We requested it and did not obtain it. I'm happy to join Ms. White's in issuing a subpoena. If she does, I certainly has it issued. I certainly won't object. But I do want to be clear. No one, to my knowledge, has said that LRC investigated anything concerning Emma Curtis. LRC did not investigate anything concerning the subway, and LRC did not investigate anything concerning Foxy's. I've heard nothing about that. about an LRC investigation of those things. I did hear a comment from one of the complainants that at the close of the LRC investigation, they heard something about Emma Curtis, but that wasn't part of the LRC investigation. So I'm interested to see what LRC has, but LRC refused to give it to me. It is not my duty. I have given Ms. White's everything that I have, but I have not relied on an LRC investigation in any way in presenting these charges here.
Representative Simpson, did you have a question? I saw you activate your screen.
No, I do not. I do not.
Okay. And so is the relevance that is being argued, Ms. White, of that report is what? Whether or not there was training that was done?
That would
Because
be
I don't
the relevance of the policies and procedures is what guidelines governed the representatives when doing their fundraising, when meeting in their office, when engaging professionally with people. So
Well,
that's why we've asked for the policy and procedure manual and the training. The relevance of the LRC investigation is because the witnesses said they relied on that to file their complaint. They relied on, and I believe at least one witness who testified in the preliminary hearing talked about being interviewed by the LRC.
Okay. Any other questions from any members of the commission, either here or via Zoom, on this motion?
I believe the commission may recall that there was discussion about an LRC investigation as it related to respondents' legislative assistant, multiple legislative assistants. I believe that's where what the LRC investigation was about.
And again, we're verging in a public hearing into things that are not related to these three charges.
Except they're bringing in they're bringing that in. And again, if we're going to talk about motivation, then once we get the LRC report, which I was not able to follow up on, if we get that, it could support, and I'm absolutely in favor of getting it, but it also could raise additional questions about other of respondents' conduct. We'll just have, we can see what it says.
Okay. All right. Having heard that motion, the next one is the motion to quash filed by respondent regarding health records.
And very briefly on the motion to quash the subpoena for Representative Grossberg's entirety of his medical records, both physical and mental. These are minor administrative charges, again, related strictly to the legislative code of ethics and conduct, the specific statutory language. Representative Grossberg has testified very openly and honestly about the diagnoses he carries. He has provided the report of Dr. Olson, who initially treated him for several decades and diagnosed his conditions. He's also provided a report from his treating therapist, who is working with him and has been for several years. All his providers have taught together. He also has physical health providers and various other, marriage counseling, obviously, after this difficult time. There is no need, if an elected official comes before you, particularly as he's going to in a public hearing and says, I carry these diagnoses and these are the difficult ways that diagnosis has impacted my life, there is no need to have enforcement counsel roaming through his medical records to see what's happened in the last 20 years of his life. We have to draw the line as an administrative body. We are looking at very narrow things. Let's look at that. If he testifies this impacted me, I suppose enforcement counsel could have someone come on and say, no, that's not how Tourette's or neurodiversity or ADHD works. But he does not need to go through the medical records. And the providers are very clear. These are mental health records, which are very strictly protected. And again, and I want to assure you, Chairman Nichols, I am not impugning any member of this committee when I'm saying, but things have leaked, things have gone. Things have traveled to the media and in a game of telephone have turned into something else. We are not turning over confidential mental health records of anybody, any witness, any participant in this matter, because we don't trust that those would not leak, would not walk, but more importantly, because they are not relevant to these narrow issues. You should rely on your elected officials when they testify about a very difficult personal thing to say. And as we look out, because of these statements have been made by Representative Grossberg, the community of people across the Commonwealth who suffer from those conditions is so grateful that somebody who is successful at a high level can admit, hey, I have terrible ADHD, I have Tourette's, I have neurodiversity conditions, and it impacts my life, and I'm working on that. And that's what he said. I don't think we need to question it further than that, and we certainly don't need to delve into decades of mental health records.
Mr. Jenkins?
Well, first, as to the motion to quash itself, there is no subpoena here to quash. If we were to treat this perhaps as a motion for a protective order, I suppose, which is not really before us. But I would point out that the first report that we had, the reports, we received 2 reports from Dr. Olson that were unsigned. Now, as part of a reply, respondent submitted a verified report from Dr. Olson. Now, those are reports, they're not records. You know, what we're used to, and the attorneys here are used to working under the rules of civil procedure to obtain relevant records to support then the reports. Once an issue is raised, all we're doing is investigating that issue to look at the records that a report then is relied upon. Here, the questions that come up, the very first report that I have from Dr. Olson, again, unsigned, but it speaks of treatment from a long time ago. Now, I did find out, because I thought, well, if I had to subpoena Dr. Olson's records, how would I do that? Well, I couldn't find him at the University of Louisville. Then I looked at the address. Well, the address is a home address, apparently. Well, if he's not maintaining an office practice, is he still licensed? He's not, doesn't have an active license. Counsel said, well, all he has to do is pay a fee and get his and get caught up on his continuing medical education. Well, no, that's not right. He would have to undergo a clinical assessment in order to get his license back, especially if his license has been inactive as long as 6 years. The first report that we had made reference to ADHD and neurodiversity. The second report that we had a year later mentions Tourette's. Well, if he had actually treated Tourette's, then why didn't he mention it in the first report? That's why I need to see the records. Dr. Olson's report applauds respondent for carrying through on his treatment. The record from Dr. Frankel, which according to the report is an evaluation. And an evaluation in legal circles means something. It's a one-time thing. It's not a treatment record. It's an evaluation. And we have independent medical, independent psychiatric evaluations all the time. This purports to be an evaluation, not treatment. But the report says that respondent acknowledges that his ADHD has gone untreated for some time. But Dr. Olson has applauded him for his ongoing treatment. Then Dr. Olson's report goes from the past tense, summarizing records from the past, to the present. He can't treat him now. He can't treat him now. So I don't know what he's relying on when he's speaking in the present tense. If he's speaking in the present tense, then he's practicing medicine, which, according to the records of the Board of Medical Licensure, he hasn't done since 2019. I can't send somebody to a doctor for an independent medical evaluation and assessment of somebody based on how that patient presents on a particular day unless that healthcare provider is licensed. So that's why I have questions about the report, because it speaks in the present tense. The third medical report that they've produced is from an addiction specialist, and it doesn't address the ADHD. There's been considerable discussion from counsel about autism. I mean, nobody's talked about autism in the medical records. So that's why they've put it in, that they have put the records in issue. The records in and of themselves are contradictory, and there have been statements about other things that he's treated with that is not supported by the records. And respondent even testified at his preliminary hearing about other providers that he's currently treating with. We don't have reports from them. He mentioned, Dr. Neustadt and a Dr. Tesh or something. So there are other records, reports that might be more relevant, but we don't have those. And under the rules of civil procedure, under the rules that we operate by, there are ways of authenticating medical records, and that hasn't been done here. It could have been, but it wasn't. And I'm trying to get them authenticated. I'm trying to get authenticated records so we can see where we stand, we can see the proper diagnoses, and we can see the records that these reports are based on.
And I would remind the commission that under oath, Representative Grossberg said, I've gone several years, my treating psychiatrist retired, we're still talk, but he retired, and I felt foolishly I was well enough that I didn't have to have treatment. I was elected straight representative. This is in the preliminary hearing testimony. I let treatment lapse. Now I'm back. He did reference several of the physical health providers who are his prescribers that are in the record there. I think this is plenty to move forward and say he's admitted these diagnoses. He's provided the statements of those who are working with him on this. He also has other counselors and other physical health providers. We don't need, as a commission, to see 20 years of mental health records to know, as we look at Representative Grossberg and his honest assessment and admissions, that he suffers from these issues. Neurodiversity includes anything on the autism spectrum. I think that didn't go diagnosed or wasn't diagnosed very well 30, 40 years ago when he was a child, and is rarely diagnosed in adults, but it's included in the spectrum of neurodiversity. He's been very honest. Again, these are 3 small administrative matters. We need to move forward and not try to put his mental health records at risk of disclosure and not humiliate the man further. We need to just move forward focusing on what we have. There's plenty for everybody to rely on. Dr. Olson is a professor emeritus at a well-known med school. He's not making stuff up, as counsel appears to intimate.
I'm not saying he's making anything up at all. I'm saying he's getting information from someplace. I need to know where that's coming from. That's it. It can't be coming from current treatment of the patient.
Any questions by any of the commissioners on this motion? Sorry, let me go with the commissioners that are here via Zoom. Does anyone have any questions on this particular motion? I see Tanya, you're shaking your head. Can't see you, Arnold. If it's
No, I have no questions. I've read so much relative to the
Sorry.
various. I'm at peace.
okay. Mr. Santoro. I guess I'll ask a few. And I guess this question is for you, Ms. Weitz. It's kind of a bigger picture question. Is this issue of his conditions even relevant? I mean, do you intend to raise this in any way, these diagnoses, at the adjudicatory hearing?
Yes, I think he will say, these are my diagnoses. They lead to poor social skills and blurting things out and texting and saying things I shouldn't in the heat of the moment and not reading social cues. And I think we see, at least in what the House leadership's consultants, paid consultants, say happened on the phone call with the subway, that maybe language came out too fast and it was clarified later. I think we see in the discussion with the issue advocate that he did not recognize Ms. Curtis' social cues. I think those are relevant. I don't think we need to delve into 20 years of medical records. If somebody tells you I have this really embarrassing diagnosis and it may have made me fail to recognize social cues, I don't think we need to go further than that, particularly when we have Dr. Elson, who diagnosed him, and the therapist who's currently treating him saying, we're treating him. If Mr. Jenkins wants to call them to say that in person, I'm sure they'd be able to do that.
So
I don't think we need the records.
I mean, I would, as I sit here, tend to agree on certain medical issues, right? Like if, I don't know, people can have all sorts of things that, if it's you have a, obviously this is not the case, but I'm saying like you had a tumor, you hadn't spoken of an illness with the rest of your family, there are certain things that would be irrelevant for this particular case that I don't see why, that would be something that enforcement counsel would have need of. If I'm talking, when I say medical, I'm not talking about ADHD or something like that. I know that could be medical, but I mean something like, your heart, other things that are irrelevant for this proceeding. But if I understand you, and I guess I'm asking, is the idea, I think you contend on the one hand that he didn't say certain things possibly at all. But
Correct.
If we were to find that he did, that there would be a condition that you feel would be exculpatory in terms of whether he intended to say or do something. Is that
I
fair?
think it is exculpatory to the extent that it undermines any claim of intent or, pattern. He's a horrible person and he does this. And he would say, no, I blurt things out. I've carried this diagnosis since college. I don't think you need anybody's mental health records to support that. I think opinion from a provider is plenty sufficient for this commission's purposes. We're not talking jail. We're not talking a huge civil judgment. We're not talking removal from office. We're talking about, a $4,000 fine maximum and a public reprimand. You have enough information. We don't need to delve into records, and given the leaks that have occurred throughout this case, we are not providing mental health records to enforcement counsel.
Mr. Jenkins, if they were not raising the issue of any of these conditions, would it be relevant to your investigation or
No.
your case then?
No. But again, they have raised them as it goes to intent. I do want to be very clear. I have not spoken to anybody who I'm aware of who has leaked anything to the newspapers, and I've certainly not spoken to anybody in the media about this, as seems to have been alleged here. What this commission has done is adopted the rules of civil procedure, and that's all that's all I'm not asking for special treatment. I'm not asking to introduce records in an improper way, but I'm asking that the records be authenticated and properly supported. And here it's been stated in response to, I think, to the motion in limine that, well, everybody knows, it's public knowledge how ADHD and Tourette's and autism and neurodiversity affects people. I don't believe any of us would, maybe public knowledge to people with the conditions or to Ms. White's, but I don't know that, I don't know how ADHD affects people. I don't know how being off or on any of the medications that might treat these conditions might affect, or then how alcohol, the consumption of 5 to 8 drinks of alcohol in an office might affect the medication. That's where we need the medical proof to find out more about the condition and if he was on the medication at the time. And again, we have to see what he had actually been prescribed and by whom, and see those records, then we'll know what the medications were, and then we know to ask the appropriate questions of the providers. All we're trying to do is get the information, and that's been refused. We followed the rules of civil procedure. I followed them by appropriately responding to everything, turning everything over that I had. I've gotten nothing back. All I'm asking for is for the rules of civil procedure to be followed.
I think Representative Grossberg was very clear in his testimony under oath that he was not on medication at the time. He said there was a several-year period that he stopped taking it. He thought he was okay. So the medication issue is just a red herring. It's already in the record.
I don't believe he testified to that effect.
So, I mean, I think the difficulty here on this, at least for me, is that there are allegations with respect to Representative Grossberg. Respondent has said, well, relevant to that is this condition or a set of conditions. If that, because of these conditions, the commission should find either directly or in some combination with other facts or issues that there was no ethics violation. And so I think what enforcement counsel is saying is that if that's the case and you're using that as part of your defense, that he has a right to examine the basis of that. Now, I understand, I think what you're saying, which is that there could be a whole host of information over years of treatment that may be completely irrelevant to that. And so I guess I'm
No, what I'm saying is you have reports from the providers who've treated him relevant to this condition, diagnosed him and treated him, and are currently treating him, and those should be a sufficient basis. Now, we're welcome to go, I mean, I can certainly go back and have Hillary notarize her record and say, yes, okay, here's my notarized statement, I'm counseling him for these conditions. We can certainly provide them as witnesses. We do not need to put mental health records in an unprotected position.
Is it
For
enforcement?
an elected official.
Sure. Is it enforcement counsel's position that you wish to depose these people or put them on the stand? I guess I'm not trying to put words in your mouth, but maybe you articulate it for me. The relevance of the records for the purposes of either putting these people on, deposing them, or addressing this contention by respondent.
There were a lot of ors there. Yes, what I'm interested in is seeing the records, not a report. I want to see the records because that's what supports the report. And then we'll make a decision whether there would be, see, I thought respondent would be taking a deposition to support the effects of these medical conditions on his actions. When I was asking for discovery, that was to prepare myself for an eventual deposition that I thought that they would be taking, or perhaps calling somebody alive. Apparently they don't plan on doing that. But in order for us to know what the diagnoses are and to see what the providers themselves have counseled the respondent about, did they counsel him about, here's what will happen if you don't take your medication, and then he doesn't take his medication? Well, to me that's relevant as to the intent. So we have to see what the ongoing treatment was.
Okay, Mr. Chairman, you have a question?
Yeah, I'm going to ask this question pretty directly because it seems to me in a sense of fairness. Is it your intention to introduce this information at hearing?
It is my intention to have Representative Grossberg testify, as he did at the preliminary hearing, that he carries certain diagnoses that they have impacted his life and that he believes they may have contributed to his behavior. That's Again, under the Code of Ethics, I don't know if you consider that a defense, but I think that's a fair testimony and an appropriate thing for him to say, the same way he would if he said, man, I have terrible eczema, so I just kept doing this the whole time. I didn't mean to be making a rude gesture. I don't think we need 20 years of mental health records to prove whether or not he had eczema.
No.
I think we need to see that this is a minor administrative hearing. It's narrowly tailored. This is not a case where we need mental health records from an elected official.
That's not my question. My question is, do you intend to proffer these reports at hearing as evidence?
No, sir. Not at this point. I do not intend that, no. I intend Representative Grossberg to speak honestly as he did at the preliminary.
Because it seems to me, and I'm not an attorney, but out of a sense of fairness, if those reports are going to be entered into the hearing record, that counsel, opposing counsel, has a right to go after those records.
Those reports were provided as discovery responses after significant objection by me and by the providers. No, we do not intend to put the reports into evidence. They're not. This is a very narrow issue. It's important to you to know how Representative Grossberg felt and thinks he acted and why. I don't think you want 20 years of his medical records. So we are not intending to put
It's
them
not a
on. We are
matter-
not intending to have medical providers testify.
Yeah, it's not
This
my.
was just a discovery response, and in discovery, you ask for the world and narrow it down to what you're admitting. And we reluctantly provided reports.
Well,
Okay,
in fairness, they actually provided two of the reports before the discovery. That the two of the reports were provided last year. He can't reference his treatment unless he has supporting documentation. And there is serious concerns about then that documentation. If he says, I was told I needed to be on medication for these conditions, and then makes the conscious choice not to do so, he can't, in my view, rely then on that conscious decision, knowing the effects of these conditions on his actions, and then say, oh, I didn't intend that treatment, or I didn't intend those actions.
And that's a question to
that was
ask
his
at the
conscious
hearing.
choice.
He's going to testify honestly just as he did before.
So we need to see those records to see what the effects of going on and off treatment may be. They have said, Dr. Olson has said in his report that respondent has followed the treatment.
Dr. Olson treated him, as you point out earlier, till 2019.
Except he speaks in the present tense as though it's ongoing treatment. And that's the problem, where he goes and starts speaking in the present tense. That is the practice of medicine, in talking about a prior diagnosis on current observations.
I think that's ranging far, far away from this. Representative Grossberg is going to testify. We will have no medical experts, or the time to divulge witnesses hasn't come, but it is not my intent to have any medical or clinical experts testify,
okay. So
or
you,
to present the reports.
you don't, just to be perfectly clear, you don't intend to introduce these letters
No, sir.
or any other information
Not at this time,
or any
no, sir.
testimony from these people
No, sir.
regarding all that will come from Representative Grossberg.
Correct. Yes, sir.
Okay.
Well, when we say not at this time, it's either kind of a
Yeah.
Fisher cut bait moment
I
here,
mean,
because he's saying that
something could change if Robert files something or puts on his witness list Dr. So-and-so, then yes, I will rebut that. But as direct evidence, as in my case in chief, no, sir, I do not.
So, but there's a motion in limine that we are also, I think, going to take up here, that where I think, well, there's two. There's the motion to compel, and then there's also the motion in limine where enforcement counsel is saying, well, they haven't given me this, so there should be the sanction of they can't introduce anything of it at the hearing, which I think you have proposed. And then
I do,
also
as
he's asking
rebuttal.
for that subject matter to be excluded from evidence in a motion in limine, and you're saying, no, it's important.
It is.
We-
Through Representative Grossberg. I'm not intending to provide any medical records, any medical reports, any clinician or medical testimony unless I need them as rebuttal. My intent is to have Representative Grossberg testify as to his life and his conditions and how they impact him and how he deals with them, just as he did in the preliminary hearing. And I don't think medical records should play a part in this.
But I mean, he can't self-diagnose and say, I
No,
have all
he can
these
say,
conditions
I
and
have
they're
been treated
exculpatory."
since college for these conditions. Anybody can.
Okay.
Witnesses do all the time.
And then
Well-
And if enforcement counsel objects and says, no, I don't believe you have this diagnosis, he can put on an expert and will rebut.
but once he starts testifying about prior diagnosis and what he's been told, then that's hearsay. He has to have proof or authenticated proof.
Then make a hearsay objection. If you don't think someone can
Auth-
testify about their own health, go ahead and make a hearsay
what they've
objection.
been what they've been told, and so clearly this is all relevant to an issue that can come up before the commission at the adjudicatory hearing. All we're trying to do right now is to look at the records under a under a protective order, which I offered to do long ago, and we can turn the records back over to respondent or respondent's counsel
We are not
after this matter is over. But in order for them to rely on these records as a basis for any sort of testimony, I have to see them, especially when the records in and of themselves are contradictory. Or the reports, excuse me.
But if those reports, counsel, are not entered into the record at the hearing, we can't consider them anyway. Or we shouldn't consider them anyway. We're faced with a lot of things right now that we're being given information that we shouldn't know, or that we would prefer not to know. And I'd prefer not to have known that going into the hearing, but I can make a fair decision even knowing it. But if it's not a part of the hearing, how is that problematic?
Well, he's making it part of the hearing. That's the issue. He's going to testify about his diagnoses. That then makes the reports relevant, because then I should be able, if he comes in and says, well, they've told me this is how my, well, first, if he tries to say this is how I've been told, or this is how it affects me, well, that has to be based on something he's been apparently told by his providers. So I have to see the records. I have to know what the providers have told him about his medical condition. It may be that we choose to not, either Ms. White's or I choose to not bring this up at the hearing. But in order for us to be prepared for the hearing, we have to see what the records are. He can't just come in and say, I've been diagnosed with a condition, and this provider says this. He mentioned this condition a year ago, and now this year he doesn't mention this condition a year ago, but he says, this is how it affects my condition today. But now I've not treated with that provider since at least 2019, even though the provider's talking as though it's ongoing treatment. And then I have apparently a one-time evaluation report from a psychiatrist. And now I think maybe they're saying, well, it's actually a treating psychiatrist. Well, if that's the case, then that report in front of me is incorrect. So that's why all of this information is relevant, because we have to see what is consistent, what the records say, what he's been told about the conditions, what he's not been told, what the interactions may be with medication, and even potentially with his current treating physician who is prescribing medication for these conditions, but apparently the implication was, well, they're just prescribing medication. The doctor is not really, I don't know if it was that he's not really treating him for it, but it's relevant to the medical condition itself and what he can properly say about his condition.
I think somebody can always testify to what they believe they have and how they believe it impacts them. I don't think that we need medical evidence, and should enforcement counsel wish to provide an expert, we'll rebut. I mean, we don't want the hearing to go on for 5 weeks. We just need to to narrowly tailor this. But he does have to be able to say, this is my lived experience.
Commissioner Russell.
Well,
Yep.
to me, it just goes to the weight of his testimony. If he wants to come in and just talk on his own and not produce a doctor, not produce a medical report, then we weigh whether we believe him or we don't believe him. That's his choice that he's making, that he has a choice of providing medical reports and making his case stronger, or he has a choice of just talking about it. To me, it goes to the weight of his credibility, and that's the extent of it.
I understand. I don't think there's any court anywhere that would allow a party to say, I have this condition, but the other side, you're not entitled to any of their medical records. I have to be able to know what the true diagnoses are, what he's been told about them, what sort of treatment has been recommended for him, and whether he's followed it. And I can't tell that from these records because the records are inconsistent. And I'll have to use these records then to impeach him. But the records aren't authenticated. And that concerns me. And even where Dr. Olson's report goes from speaking in the past to the present tense, where does that knowledge come from of his current, of those present tense paragraphs? Where's it come from?
But that wouldn't even be in the records. He's just going to get up there and talk, and then we take it for what it's worth. We can disregard it. We can believe him. We don't know how he's going to sound that day.
Well,
but it certainly, to me, goes in my mind whether I would believe it or not by the fact that he's not willing to produce a doctor and he's not willing to produce.
Well, he can't testify as to a medical condition without appropriately authenticated medical records, and that's not occurred.
I don't believe that's true. I think you can talk about your lived experience.
Okay, any other questions by commissioners on this motion?
No.
Take a break too.
Yeah, I need to take a break.
Okay, it's probably a good idea. We'll take let's say a 10-minute break and then
Great.
at 11.
Recording stopped.
Go ahead. Turn it off.